All right, let's take a look at some cases for examples. There's a lot more in the reading material as well as on the website involving the use of videos, making online videos. So, without ado, we're going to start with this case. This involves a young man a photographer who posed the Barbie doll in some very odd positions and took photographs and was selling the photographs. And there's a lot more than these ones that I show you here. Mattel, who owns Barbie, sued the photographer and owner of the Walking Mountain Productions, claiming that it infringed on the famous Barbie doll by creating a series of photographs depicting a Barbie doll in absurd and sometimes sexualized positions, usually posed with various kitchen appliances. The defendant asserted that his work was an attempt to critique the objectification of women, and the plaintiff appealed the district court's ruling that the defendant's Barbie doll photographs were parodies, and they were in fact protected by fair use. So the question was whether or not the defendant's photos of using Barbie dolls as part of a social critique constituted fair use. And going through the factors, this is, by the way, out in California. This is the Ninth Circuit Court, which is the appeals court for the federal court system. The one above this would be the Supreme Court if they decided to take this case, but they did not. This case is from 2003. So the court actually agreed, the appeals court actually agreed with the lower court in finding that the use of the Barbie doll was a fair use. The court based its decision finding that the defendants used the dolls, going through the factors here, going through the dolls for the purpose. What was the purpose? The purpose of parody was transformative, and that the extremely transformative nature and parodic quality of the defendant's work made its commercial qualities become less important. So the court also found that the extent, that's the next factor, of defendant's copying of the dolls was justified in light of the purpose as a parody and the photographic medium that was used. And the court also found that the defendant's use as a parody was highly unlikely to substitute for products in Mattel's markets or the markets of Mattel's licensee. And I'd also point out that there was no evidence that, in fact, Mattel could be using Barbie or look to this market as a derivative. It wasn't foreseeable, so it wouldn't be subjected to the derivative rights. So in this instance, it's a parody. So it met the four factors of the test. Had a critique message to it, as weird as it looks and sounds. Nonetheless, he was allowed to make his photographs, which he was selling, by the way, at fairs, not making tons of money, but nonetheless, he was making some money, but it had no effect on what Mattel was doing with Barbie. Basically, they just didn't like Barbie being used in that way. Our next case involves two photographers. The defendant, who is a well-known visual artist and was commissioned to create a series of 7 billboards for $2 million. He is also known for taking objects and images from popular media and consumer advertising and incorporating them into his artwork, a practice which is referred to as appropriation art. In the creation of one of his paintings, titled Niagara, Coons used part of an ad that he saw in Allure magazine, and the ad was titled Silk Sandals, which was taken by photographer Blanche, our plaintiff, who shows a woman's lower legs and feet adorned with some nail polish and glittery Gucci sandals, and they're resting on a man's lap. He included in the painting only the legs and feet from the photograph, leaving out the background and the airplane cabin. I won't go into, you could see it. I'm not going to go into the details, but you could tell which one it is if you're moving from the left to the right. It's the second pair of feet in. Those are the ones that's the claim of copyright infringement. He didn't seek permission. Another point in this facts, besides looking what it looks like, he admits that he used it, and that he did not seek permission before using it, and he's claiming that his use is fair use. So the court goes through the factor test. The first one they look at is the purpose and character of the use, including whether or not there's a commercial use or it's a not-for-profit use. Obviously, it's for profit because he's making $2 million to do this. The other note that they look at is the purpose. What's the purpose behind these? And does it make this work transformative? And the plaintiff had said that his goal in creating his ad was to add sexiness to the sandals. The defendant wanted the viewer to think about his or her personal experience with these objects, products, and images, and at the same time gain new insight into how these affect our lives. So there's different goals, which leads to this being transformative in nature. Also, the work being used, is the paraffin, is quote-unquote raw material in the furtherance of distinct creative and communication objectives. So the use is transformative. The court pointed out that the test for determining transformative is whether it simply supersedes the objects of the original creation or adds something new instead with a further purpose or different character, changing the first with new expression, meaning, or message. And in that instance, it fit as transformative. The further discussion is the defendant indicated that his image was intended to create commentary among viewers relative to this image, to give this image veracity. The plaintiff didn't challenge that point, but it was enough, at least for this factor, for the court to say the defendant was justified in using the image. The plaintiff complains that he didn't ask for permission, so that's bad faith. The court said, well, no, that's not the issue. Whether or not that was good faith doesn't matter because there is no requirement that you have to seek permission, especially if you're going to claim that it's a fair use. So that was tossed out the door. Then they moved on to the second factor, which is the nature of the copyright work. If the work is creative rather than factual, that weighs in favor of the copyright holder. And if the work has been published, that weighs against the copyright holder. So in this case, the work was creative in nature, which weighs for the plaintiff, but it was published, which weighs for the defendant. Regardless, where a use is transformative, as in this case, the court said, the second fair use factor may be of limited use since the use is not exploiting the work's creative virtues. So they moved on to the third factor, is the amount and substantiality of the portion used in relation to the copyright work as a whole. And the question becomes whether the quantity and the value of the materials used are reasonable in relation to the purpose of the copying. By extracting only the image of the leg, feet, and sandals, rather than also including the other elements from the plaintiff's photo, defendant made a reasonable use of the image that was not excessive for the purpose for which he wanted. So the defendant copied only that portion of the image necessary to invoke certain style of mass communication. So that factor weighed in favor of the defendant. And then finally, they moved on to the fourth factor. In fair use is the effect of the use upon the potential market for or value of the copyrighted work. And in this case, the question is whether the secondary use replaced the market for the original. And the plaintiff here had no proof. Remember, the plaintiff has to come up with the proof about not affecting the market. Plaintiff acknowledged that she had not published or licensed this photo since it appeared in the magazine, that she's never licensed any of her photographs for use in works of graphic or other visual art. that Kuhn's use of the photograph did not cause any harm to her career or upset any plans she had for Silk Sandals, or any other photograph she had. So the value of Silk Sandals did not decrease because of the defendant's alleged infringement. So based on all of that, weighing the 4 factors, the court concluded that was a fair use. So when you're looking at a fair use analysis, fact pattern, you gotta kind of have to work through those 4 factors and considering those main situations of critiquing, commentary, news reporting, the other, education, research, scholarship, teaching, and then move into your 4 factors. Didn't stop there for Mr. Coons, however. He was sued yet again. Another case coming from New York, Second Circuit. Our plaintiff is Rogers. He's a professional photographer. He took a black and white photo of a man and a woman holding several puppies in their arms, entitled Puppies. That's the one to the left. The photo was used on greeting cards, postcards, and other various merchandise. Jeff Koons, as I just described, he's his own artist in his own way, saw this wonderful photograph, removed the copyright notice from the picture, and created a sculpture from the photo. Koons asked his assistants to copy as much detail as possible from the photographs. The only changes made during the transition were large noses on the puppies, blue fur, and the man and woman had flowers in their hair. The sculpture was named String of Puppies and became a success. Reportedly, Koons sold 3 of these sculptures for a total of $367,000. Rogers, upon discovering that his work had been reproduced into a sculpture, sued. And Koons said, yep, I copied that work, but guess what? It's a parody. And it's fair use. So this case proceeds, and I am just going to give you the overview. I kind of went through a very detailed checklist on the other one. I'll hit these ones pretty quickly. The court found infringement, and in interpreting the fair use defense, the court said Koons' conduct, especially the tearing off of the copyright mark on the Rogers note card prior to sending it to his assistants, suggests bad faith in Koons' use of the plaintiff's work and goes against a finding of fair use. Koons' substantial profit from his intentionally exploitive use of Rogers' work also goes against the finding of fair use. The Act provides that comment on or criticism of a copyrighted work may be a valid use under the fair use doctrine. However, String of Puppies cannot be considered a comment on or criticism of the photograph Puppies. Parody or satire, as the court defines it, is when one artist, for comic effort or social commentary, closely imitates the style of another artist, and in doing so creates a new artwork that makes ridiculous the style and expression of the original. It is the rule in this court that though the satire need not be only of the copied work, and may, as Mr. Rogers argues, a String of Puppies, also be a parody of modern society. The copied work must be, at least in part, an object of the parody. Otherwise, there would be no need to conjure up the original work. So the court rejected Koons' claim of parody because it did not believe that Koons was commenting on the original work specifically, and his argument that his sculpture is a comment on a materialistic society falls short of that rule. So here he did not win his fair use. The court had basically looked at his bad faith under the first element, and then the derivative component and the money making. This is something that certainly the photographer would foreseeably be able to engage in, is taking his photograph and having it turned into a sculpture. That's a derivative work. So there was no fair use in this particular instance. I want to revisit the Seinfeld trivia game case we talked about relative to derivative works. A little recap: Castle Rock made the TV show Seinfeld. Carol, our defendant, this is Castle Rock Entertainment versus Carol Publishing Group, Carol published a book of containing trivia questions and answers related to the TV show. Again, this is another New York case, Second Circuit New York case. So Castle Rock sues for infringement, and one of the arguments that Carol made was that this book was not infringement because it was covered by the fair use exception. However, the court found that it was not, based on the 4-factor test for determining if something was fair use. Number one, looking at the commercial versus non-commercial use, the court found that Carol's book was commercial and not criticism, commentary, or parody of the original. The nature of the copyrighted work, the court found that fictional works like Seinfeld have greater protection than non-fictional works. The amount of the original work used is the next third factor, and the court found that Carol's book copied the original more than necessary to further the purpose and character of the use. Like, she copied the whole show, like she needed the show to create her trivia book. The effect on the potential market, the court found that even though Castle Rock did not produce a Seinfeld trivia book, their copyright gave them the exclusive right to distribution, and Carol's book infringed that right by reducing the potential for, I should say not distribution, but derivative, the right to derivative, and Carol's book infringed that right by reducing the potential for Castle Rock to market their work. So that was foreseeable. You could see that Castle Rock could potentially take and create a trivia book regarding Seinfeld. As a matter of fact, there's a TV show that just recently did a Trivia Pursuit game. I don't remember. Big Bang Theory. So that's well within their right to do. All right, moving on. We got a few more cases here of significance because the law tends to get a little broader as we move forward in time. We're now at 2013. Those were from the early 2000s, the ones we just went through. We're into 2013 now. Again, a New York case out of Second Circuit. And in this case, Patrick Carriou is a professional photographer who published a book of portraits and landscape photographs that he titled Yasta. And Richard Prince, he's another well-known appropriation artist. He altered and incorporated a number of Carriou's photographs into a series of paintings and collages that he called the Canal Zone, which Prince had an exhibit on in one of New York City's finest galleries. Carriou sued Prince and the galleries for infringement. In response, Mr. Prince raises the defense of self-defense. And as we work through our, I'll say the lower court ruled in favor of Carriou, saying that this was not a fair use because there was no comment or critique on the original photograph. So then Prince appeals. So now we're looking at the decision of the appeals court as we move forward. Now let me direct you on these photographs here that you see before you. The one to the left is the original. That's Carriou's. That's just one photo, but he has lots of photos like this. And on the right-hand side, as you can see, the guitar in the hand, and in there, looks like in his hands, and the changing in his face, those couple things. That's what Prince does with a number of pictures. That's what it will look. That's what his quote-unquote his transformation looks like. Okay? So on appeal, our appellate court goes through the 4-factor test. In order to be fair use, a secondary use must, and in this case, focuses just on transformation. In order to be fair use, a secondary use must transform the original by employing it in a different manner or for a different purpose than the original in order to produce a new expression, meaning, or message. A secondary use does not need to comment on or critique the original in order to be transformative as long as it produces a new message. So this is kind of a new rule out of our New York courts saying now you don't need the comment and critique component as long as your transformation changes the message, makes a new message. So, as we move forward, looking at this case, whether or not an art is transformative depends on how many reasonably be perceived and not the artist's attention. Not the artist's intentions, how it's reasonably perceived. Even though Prince expressly stated he did not have a message, the court still found that most observers would see as Prince's canal zone as having a radically different purpose than Carews' Yasta, right? Even if the secondary use damages or destroys the market for the original material, it can still be fair use as long as its nature and target audience are different from those of the original. So this court took a very liberal change in direction. Give you some background. Mr. Prince's artwork, some of his work have sold over $2 million or made him over $2 million with high-end collectors, while Carew only made $8,000. So, and the Second Circuit, in reviewing the fourth factor, had found that there was no evidence that Prince's transformative use had touched, much less upset the market of the original photographs. So, that is where we're headed. And now check out this one from 2015. This is Mr. Prince again. What he does is now he's taken to Instagram, and he pulls off random people's pictures. These aren't people he knows. He doesn't go and ask for them. He just posts. He just takes them. He takes them, right? And then he puts them on big frames, and he's been adding a comment. He'll add a comment at the bottom. He'll put his tag on it. He'll say things like the drunk Instagram posts, or if you need, he'll put his little tagline at Richard Prince 1234 on the end. But he hasn't really done anything. He's got this young lady with the blue hair, doe deer, walked into the shop and saw her picture and was like, whoa, like freaked out. Like, that's my picture from my Instagram page. So he takes these, he blows them up, and he sells them for $90,000 each. And he makes this kind of money using other people's Instagram pictures. Now, you might be saying, well, how is that fair? Well, nobody has actually sued him yet, because these are just, I don't want to say these are just ordinary people. These are people who don't want to spend the time and the money. It costs a lot of money to go to court to sue him to stop. So some folks have actually been taking his pictures when they find it and kind of doing the same thing. He's got an Instagram account, and they don't have any pictures on it. He doesn't want to put his pictures on it. And Instagram, there was a recent case involving Instagram where, and if you look at the terms and conditions, here's a side note, if you use Instagram, make sure you're not public and you're private. Your feed is private. Once you make it public, you have given Instagram a sub-license to license your pictures out without any reimbursement to you. So you are giving Instagram permission to use or sub-license your photos. That's different than what Mr. Prince is doing. He's not even asking Instagram. He's just going on and taking them. Now the question is his use transformative enough now that the court has kind of expanded that a little bit, like the littlest of alteration? But the question becomes, is it a new message? I don't know if he gets there on this, but it'll take somebody from Instagram who sees their picture up on his gallery to sue him. Otherwise, he's still gonna do it. Fox News recently tried to expand, or is trying to expand, this case is still going on, still trying to expand the fair use doctrine. They argue that social media is an inherently transformative media, and therefore it's protected by the fair use doctrine. Hence, an interpretation, anything is fair game. If you find it on social media, it's fair to use. That's Fox News' argument. In a case where one of their commentaries posted this photograph, very famous photograph. I'm sure you guys seen this around from 9/11. The licensee holder has made millions of dollars. It's been on a stamp, and the holder of this copyright polices this photo like nobody's business. So Fox argues that expression on social media and on Facebook in particular is thus inherently intertwined with comment and criticism purposes, with the comment and criticism purposes that the Copyright Act sets forth as presumptively fair, meaning every post is an invitation. This is their argument. Think about this. Every post is an invitation for others to comment and criticize. Every message and images invites that expression. A context-sensitive test for transformativeness then will necessarily account for the fact that Facebook and social media sites are by design used for purposes of comment and criticism, and as such, the test will inevitably favor use on social media. Is that a far stretch, or is that a far stretch? So anything on social media goes, according to Fox. And it's kind of funny since that's, their content-based company, which, they depend on copyright laws, that they would go to such lengths to kind of get around that, to, okay, we used a picture, let's go pay for it. It's interesting. We'll see. I doubt it will go that far. It'll probably settle. But nonetheless, think about that, right? If you got a Facebook account, what's happening? You're doing likes, people are commenting, might see criticism. Could that be enough to transform the use of whatever the subject of that critique or comment is? And then there's this one, same time frame, Sarah Palin. She did the same thing. She took that picture. She made it a little different. Obviously, no, she doesn't have the full picture. The full picture was in the last slide. Puts her little Sarah pack, and then then adds the "We will never forget September." Is that transformative? No, doesn't change the message. And she was also sued for using that as well. And now we have the United States Postal Service commissioned a sculpture for the Korean War Veterans Memorial. In the agreement, the sculpture adamantly retained the copyright. The U.S. Postal Service subsequently put a photo of the sculpture on a stamp, which sold millions of copies. The photographer had made the image of the snow sculptured as a present for his father, who was a Korean War veteran. So the U.S. Post Office did get a license agreement, getting permission only from the photographer to use the picture, but never from the sculptor who actually did the sculpture, who was subject to the photograph. So, question is that a fair use? Is the post office use fair? It's a little bit more key background facts here. So the plaintiff is Frank Gaylord, created the sculpture known as the Column for the Korean War Veterans Memorial in Washington, D.C. It consists of 19 stainless steel statues representing a platoon of American soldiers in the Korean War walking in formation. Defendant, the U.S. Postal Service, issued a stamp commemorating the 50th anniversary of the Korean War that included a picture of showing 14 of the 19 soldier statues. Plaintiff appealed the ruling of the lower court that said that it was a fair use. But the appellate court held that, putting an image of plaintiff's sculpture on a stamp without their permission is not fair use. Though the stamp it's altered. The colors, they added snow. The court did not find that it was transformative because it shared a common purpose with the memorial. So the message didn't change. And this is this is a federal circuit court out of D.C. So this is different from the cases we've already heard about. But the message was the same, to honor Korean War veterans. The court found that the stamp also had a clearly commercial purpose in light of the fact that they received over $17 million in sales. The court pointed out that the nature of the column being expressive and creative, and the amount of the memorial depicted, 14 of the 19 soldier sculptures, weighed against fair use. The court, however, noted that defendants' work harmed neither the value of plaintiffs' work nor the market for derivatives based on the work. But nonetheless, the court determined that this was not enough to overcome the other factors against fair use. So this was not a fair use on the part of the U.S. Postal Service. Some other cases that have come up. This is from 2015. Google was sued for whether scanning in library collections for searching is fair use, and the court said yes, it's transformative. Yeah, if you've been on Google and you search Google, you can look for books. They kind of give you some information on books. Sometimes they give you the whole books, but you can't print it. You can only scan so much, and it highlights points in it. But literally, they digitally copy entire books in there for searching purposes is what they do. So in concluding that Google's use was transformative, the court found that Google's making of a digital copy to provide a search function augments public knowledge by making available information about plaintiffs' books without providing the public with a substantial substitute for matter protected by the plaintiff's copyright interest in the original works or derivatives of them. So that was deemed a fair use. We're going to revisit the Kelly case. That was the one involving the thumbnail search. In conducting a search, if you're looking, for something, generally you get a text display. But in the case of Kelly's, this is a Ninth Circuit case, and this is a little older, might be a little outdated. We're a little up with regards to internet use. This is from 2002, but what was happening was, rather than just getting text type search, you type in something you want to search and it comes up in text form. Using this particular user, you would get, or website, you would get images instead, and the question became whether or not it's a fair use of the images, and the court said yes, it is. The images, the thumbnails, are much smaller, lower resolution. They serve an entirely different function than the Kelly, who's the photographer's original images. It helps the search engines function as a tool to help index and improve access to images on the internet and their related sites. This was deemed a fair use. Rosen versus eBay. If you use eBay, you might be taking photographs of photographs. If you're putting up a magazine, this case involves a magazine. But if you're putting up paintings or photographs and you're rephotographing them to put them up for resale, that is a fair use. A magazine company was suing eBay over allowing people to put those things up so they can sell their items, and the court said no, that's a fair use. There's a case recently involving, from last year, still out there, tweeting. If anyone uses Twitter, get to the whole, like less than 200 words you can type in to a Twitter feed. But an NBC commentator, retweeted a post of a lengthy passage of about less than 200 words. So we'll call it lengthy, but when you look at the tweet, it's lengthier than most tweets. But it was a passage from a Dr. Keith Bell's book, and Dr. Keith Bell is a sports psychologist consultant, and he sued NBC, of course, not where it originally came from, on the retweet. Why? Because NBC has money. His book might not be selling as great as he wants to, and hey, look, I might have a copyright infringement, but what are the things he has to show? Is there some kind of damage? So the question is whether or not that will be a fair use. How we're talking about a book of a few hundred words, 400 or 500 pages, not words, and a tweet of less than 200 words. So is that it? Or maybe it's de minimis. But I'm just putting it out there. You got to watch your retweets or your tweets and your social media posts. You can be infringing, and they may or may not constitute a fair use if you find, there's somebody who is not happy with what you've posted. So the last case I want to talk about, there's a link under the additional sources of the Dancing Baby case. This kind of is the case that sort of set things up for YouTube and, social media and what was going to be fair or not fair. And this case started in 2007, finally resolved and settled 2018, 2017, 2018, something like that. The child in the video is a teenager now. Basically, it's like a less than a minute clip. It's got over 1 million views, probably because of this case. And he's in a walker, and he's dancing. You can hear music faintly in the background, and it's a Prince song, "Let's Go Crazy," and he's dancing. And Universal Music Group Corp. and Prince sue her, it's a woman, and YouTube over the infringement over the use. And after this case makes its way all the way, it's Ninth Circuit, California, all the way up on appeal, the appellate court finally says a couple things which are extremely important, but it's important but might be irrelevant, and I'll tell you why on both fronts. But the court says that it is a fair use. They do a fair use analysis. They deem that it is a fair use, and that they also say, look, music industry, movie industry, any industry, before you claim that there's a copyright infringement, you need to do your own analysis of whether or not the use is fair use. You just don't. I think what they were trying to do is to kind of send a message to stop using works. They didn't want it to get out of hand. Basically, usually they send a letter to YouTube. Hey, somebody's using our stuff. They do it for, Facebook. They are police, especially the music industry. They police like nobody's business. And if you've tried to put something on social media, it either got removed really quickly or you got a letter saying, oh, notified infringement, we're taking it down, that sort of thing. But after this case, the court said, look, you have to do your own fair use analysis test before you can bring a lawsuit. And that's a pretty big message to send on one hand. However, in light of all of this, YouTube has created licensing agreements with at least the music industry, possibly the movie industry, but definitely the music industry. So if you like singing songs, you could totally make your own video and sing songs and put it up there and not be infringing, because YouTube has created those licenses. Facebook, however, if you put a song, even like it's a 5-second clip, it'll be gone. Like within moments, it'll be gone. Movies, they have to abide by the same standard of doing a fair use analysis. And when you look at the next video or the next information, one is like a reading page of online videos and online use, and the other is some examples of videos, and then I've given you like the answers of how those videos were treated. You can see even using movie clips and making mashups of movies or songs can be fair use. So that wraps up the fair use discussion. When you see some questions regarding fair use, make sure you work through the 4-factor test. And if you have any questions, let me know.